Hi, this is Melissa Nash with Checkmark Collections. Have you heard about Reg F yet? Well, you're about to. We've put together a series featuring 7 short videos aimed at topics that are most relevant to the creditor, you. We're going to cover items such as call frequency and communication caps, itemization dates, information needed in the validation notice, and so forth. These issues are important to you as the creditor, and they're definitely important to us as the collection agency. If you have any questions after these videos, please feel free to reach out to me or one of your account executives in the office, and we'll be glad to answer any of your questions. At Checkmark Collections, we always put the check back into your business.
Folks, welcome to our segment on Regulation F and the limited content message. Here is the concept underlying the reg: third-party disclosure. As we know, the FDCPA says if Michael owes a debt to me, I can't go around calling Michael's friends and telling him about the debt and trying to, besmirch his good name in the community by disclosing that he owes a debt. There is a bit of a rock and a hard place problem that has existed, or at least some courts have concluded exists, regarding voicemail messages. Here's the conundrum. In addition to not being able to make a third-party disclosure as a third-party debt collector, I need to also adequately disclose who I am in communications with a consumer. So when I leave a voicemail, on the one hand, don't I need to identify who I am to satisfy the adequate disclosure requirement? But then on the other hand, what if I haven't reached the consumer? Or what if someone else listens to the voicemail? Well, now suddenly I've made a third-party disclosures. How do we marry up compliance with both of those issues? Unhelpfully, some courts concluded in the past, well, just don't leave voicemails. You're not entitled to do that. Not particularly helpful, but thankfully, there were some compliance workarounds created and blessed by the courts in some instances. And now, happily, the CFPB has picked up some of those ideas and codified them, enshrined them in this new Reg F. And so we have the limited content message. Do you have some additional nuance, Michael? Perhaps some personal experience you'd like to share on this issue?
Yeah, thank you, Patrick. So we've all heard about FODI. Even if you're a creditor, I'm sure you've heard about FODI. And it's kind of a verbose message telling people, listen to this. If you are this person, if you aren't, I'm going to wait now, hang up. It kind of got mixed results in the courts. We handled the case Zortman, which you probably have heard of as well. And Zortman was a little bit different tactic to kind of get around this issue that Patrick's mentioning, where the name of the consumer was not given in the message that was left. So the person would then call back in to see what this was about, but it did have mini Miranda in it, and it did give the agency's name and the agency's phone number. That tended to work, and the courts generally have been okay with it. There were some quirks with it and that sort of thing, where the consumer wouldn't be the one that would call back in. It would be somebody else, and then there'd be a claim of a third-party disclosure. But the court said, no, give me a break. So we did get some traction with that. Zortman then is mentioned in the Reg F, and basically what the Reg F, once it goes into effect, will codify, if you will give us the roadmap of how to leave a limited content message. It only pertains to voicemails, but if you use it and do it the way you're supposed to, you basically have a safe harbor if a third party overhears it. So what's a limited content message have in it?
Okay.
Patrick?
There are required elements, and then there are optional elements. So to qualify for the safe harbor, you must include in your limited content message a business name for the debt collector, the condition being that the name cannot indicate that the debt collector is in the collection business. So ABC Collection Company, that could be problematic. You must also include a request that the consumer reply to the message. You must give the name of a person who can be contacted regarding the debt, as well as a telephone number that the consumer can call. So those are your 4 required. You got to have that. You get those done, you qualify for the safe harbor that, again, threads the needle of adequate disclosure, but not improper third-party disclosure.
So just to pick up on that before we talk about the optional additions, your agencies that you're working with, you may hear them starting to use acronyms. You taking the initials of their name and making that an acronym, so that they do not have, if they have collections in their name, they aren't disclosing that they're in a debt collection business. Recently, we were successful here in Minnesota in getting our statute amended that deals with collection agency licensing to allow collection agencies to register doing business as a DBA with the Department of Commerce and then collect using that DBA. That was expressly done to assist with this issue where many collection agencies have collection in their name, so that they can leave limited content messages now. Well, I shouldn't say now, so that they can leave messages now that don't denote that they're in the debt collection business. And when it becomes the law, they can do it under the Reg F. So that's something that you may be hearing from your agencies. Don't be surprised if they start letting you know that they're using a DBA.
And it's just a good opportunity to partner with your agencies and just help them with this transition into kind of a new compliance segment, new stage of life. Here's what else you can include. None of this is terribly controversial. And before I get into these, really, the caveat is the further you tiptoe away from the 4 required elements, the riskier the message gets, the less likely it becomes to be to qualify for the safe harbor. So you've got a rubric here, and I would say don't venture too far. At least your third-party collector shouldn't. So a salutation. Hello, Michael Clutho. The date and the time of the message is acceptable. As you're leaving the name of the person the consumer can reply to and the phone number, you can also leave suggested times that they might call back. And if you don't want to limit the response person to whomever is leaving the message or the assigned collector to the account, the limited content message still qualifies for the safe harbor if you leave something to the effect of, and it's okay if you call back, when you call back, you can speak to anyone, any of our representatives in the office. So that's an additional 4 pieces of data that you can insert into your third party's limited content message.
Yeah, so the CFPB actually gave some examples, and when they give examples, you pretty much want to have your agencies follow those examples. So if you're a creditor, you can ask them, what limited content messaging are you going to be using? And then you would compare it to what the CFPB indicated. So here are the 2 examples they gave. First one, this is Robin Smith calling from ABC Incorporated. Please contact me or Jim Johnson at 1-800-555-1212. End of message. Second message, which Patrick said has a little more optional information. Hi, this is Robin Smith calling from ABC Incorporated. It is 4:15 on Wednesday, September 1st. Please contact me or any of our representatives at 1-800 today until 6 p.m. Eastern Time, or any weekday from 8 a.m. to 6 p.m. Eastern Time. End of message. I would think that you'd probably want to go ahead and maybe do those hours or run an experiment. Use both of them, the short, sweet version, and then maybe a little more expanded version, and see if you get a different, or see if your agencies are getting different responses. But it's a real good opportunity to run that experiment. Both of those are safe harbors. All right, Patrick, what else do you have on limited content messages?
Well, I am hopeful, as you say, Michael, that folks will dig in to these examples and use them as their template. And I'll take another opportunity, I've said this in other forums and talks with folks, is Reg F is helpful because it provides commentary. The Bureau put thoughtful commentary into various subsections of the rule. And so I would encourage our audience to go in and read the comments, because the comments give examples of things that are either problematic or not. And it's less cryptic than just the plain text of the FDCPA. It's a bit of a guidepost. There's an interactive version of the regs available through the CFPB's website, pretty easy to use, and that's where you pulled these example messages from, right? Great resource.
Yeah, and so the whole purpose behind this limited content message is to hopefully, eliminate, dramatically lessen third-party disclosure, because we're not saying anything about the debt. And the other part of it too is the hope that we don't have a situation where your agencies have to keep calling and hanging up when they get a voicemail on the other end, because they're concerned, as Patrick indicated at the front end, how do you get past this conundrum of complying with the FDCPA and communicating with the consumer, meaningful disclosure, identity, mini Miranda. Well, anybody other than the consumer hears that, third-party disclosure. So that's that rock and hard place that Patrick mentioned. So the CFPB has given us this, frankly, I think one of the best things to come out of the Reg F is this limited content message. It will count towards, as you're leaving that message, it will count towards that 7 calls within 7 days type of thing, but it does not constitute a communication under the FDCPA, because any communication in the FDCPA would need to have that mini Miranda and that meaningful disclosure. So you're getting the meaningful disclosure out there, but you get to leave the mini Miranda off. So it's something we've wanted for a long time, and frankly is what messaging was 20 years ago under the FDCPA before cases like FODI and others came along. So we've kind of come full circle, and the CFPB is behind us. This should help your agencies have a more robust communication with the consumers, help your bottom line in collecting your debts. Anything else?
Thanks, and leave a message at the beep.
All right, thank you very much.